Thanks everybody for being here, and thank you to LES and Mark for inviting me. It's a real pleasure. As I was mentioning to somebody earlier, when I came back from Geneva, I decided that, although I'd been spending most of my time on patents during that period, I decided that my personal mission would be to elevate trade secret law and practice to the same level of respect as the registered rights. And that reflected the long career. It's been 50 years since I graduated from law school, where I happened to get into this and then fall in love with it. So I just want to start out with a little bit of story of how that happened. In fact, we're very, very close to where 50 years ago I came when Palo Alto Square was brand new to come back to the firm where I had been the first summer the year before. So this was 1973. This old 11-lawyer firm called Wilson, Mosier and Sonsini. And it was just a suburban, but a little bit of high-tech practice. But one of the clients had just coined the term Silicon Valley. And we saw the transformation from the Santa Clara Valley happening. And one of the features of that transformation was people leaving either to start their own company or to join a competitor. And so, without any intention on our part, because at that time, believe it or not, there were very few lawyers in Palo Alto, certainly relative to today. And so all these trade secret cases kept popping up. And so I ended up, just by default, I guess, doing a whole lot of that. And over the next 6, 7, 8 years, I probably handled dozens and dozens of those kinds of disputes. And I came, as I looked back on it, and as still a very young lawyer, but with a lot of these cases under my belt, I was trying to think, well, what is it that's common to all these? There were very, very different technologies, very different people, circumstances. But one thing was common to all of them. Somebody had done something stupid. When you look back. And so I thought to myself, this area, at the time I was doing divorces, neighbor fence disputes, whatever came into the courtroom, criminal, etc. But here this thing was becoming more and more part of my practice, and I thought to myself, well, I could probably do something good for the world by helping people understand what the rules of the road are in these kinds of cases, and that way this kind of litigation wouldn't happen anymore. That was my naive assumption, because, of course, there's an inexhaustible supply of human stupidity. So in 1982, believe it or not, I published this, fully expecting in my naive mind that these cases would diminish and maybe even go away. Well, of course, that didn't happen. But I did get a practice out of it because just a few weeks after my book was published in the hands of various people that the publisher had sent it to, that was back in the time when publishers, by the way, actually promoted your book. So we had the event of the IBM Hitachi trade secret case, and there were photographs of Japanese managers being led in handcuffs to the San Jose courthouse, and all of a sudden they needed a talking head about trade secrets. So, like I say, it then became a practice. I updated the book a few years later, and ended up also doing a treatise, getting into teaching. And I really found that I loved this a lot. But I didn't stick with the directly with the writing as much as I probably should have. And one of the things that when I was at WIPO and running the PCT, I discovered, because I had to go around and talk to our customers about how the PCT was working for them. And so I visited companies around the world, larger companies that were heavy users of the international patent system, to ask them about this, and kind of a customer call. And it was really interesting. Almost everybody said, gee, we're really happy with the PCT. You've got great people working there, which there are. And we don't have any suggestions on, we were in the process of putting it on a web application. At the time, they thought that was great. But what I heard over and over again from a number of people was, what we're really worried about is the stuff that we're not patenting. We have all this information that's really important to us, and we're living in a digital environment where it's stored and communicated over essentially insecure networks. And I thought, wow, this is really interesting. Back when I first got started in all of this, we didn't have networks. The only thing that you needed to do in order to protect your trade secrets was, guard the photocopier and watch who went in and out the front door. Because we didn't send information around any other way. So it was clear that I had to do something to sort of update this. And the book that I had written. And so that's what led to this book that was published when I got back from Geneva, called Secrets, Managing Information Assets in the Age of Cyber Espionage. I was told, by the way, that when you do a subtitle on a book, you need to have something in it that's very provocative. And that's where the cyber espionage. Anyway, and so that focus then shifted for me from the mostly patent world to trade secrets. And one of the lessons that I learned also when I was at WIPO was that it's very different talking about trade secrets from the perspective of being a lawyer and actually having to manage an organization that deals with confidential information on a day-to-day basis. And boy, that was the PCT in spades, because we received about 200,000 confidential applications every year. And the one thing I had nightmares about was a premature publication before the 18-month period, right? When it would be impossible to pull it back. And so I had 400 people in my group from 60 different countries, and you can imagine the varying sort of cultural attitudes and experiences with confidential information. So I had to figure out what do we do as a matter of people management to handle the access and use of very valuable information. And so a lot of that is what went into this book. And we're going to get into the PowerPoint in a second, but I wanted to explain too the graphic that I have up here. I've been using this for some years, and it represents, it's meant to remind us of the oldest, at least what to me is the oldest that I can find documented trade secrets in the world, which consist of the methods for securing and manufacturing silk. And of course it was the Chinese that discovered this. The legend has it that the princess was sitting in the garden outside under a mulberry tree, and a cocoon dropped down from the tree into her cup of tea and started to unwind. And she saw these beautiful silvery strands. Probably apocryphal. But somebody spent a lot of time figuring out how to unwind these things and then weave them into the beautiful kinds of cloth that we see represented here. And of course, for many, many years, the Chinese were able to control access to and prevent export of that technology to other places, so that during the centuries that it controlled that secret, silk was the most valuable commodity in the world, more valuable than gold. And it remained that way until sometime in the 15th century, when some Nasturtian monks happened to leave China and escape the punishment. No one figured that they had the worms in their bamboo staffs as they were walking back to Constantinople along the Silk Road. And so they were able to bring the secrets to Constantinople, where they then migrated through the rest of Europe. So, which makes it, apropos, I guess, because as Mark mentioned, recently, the book that you just saw here has been translated into Chinese, and I have to tell you, it's a very weird experience to see your name on a book that you can't read. But there we are, and I think this is a reflection of global interest in the kinds of issues that we're talking about. So, although the presentation that I'm about to give you here is built around and focuses on the U.S. experience, a great deal of what we are concerned with when it comes to maintaining control over trade secrets, rests in a global context. So, again, the goal here is that after we get all the learning that we have, that nobody here will do anything stupid, and it will help our clients not to do anything stupid. What I'm going to be talking to you about really applies and works across companies of all sizes, and all industries. And I want to mention one more thing. When we started to be concerned about trade secrets and pay attention to them, back in the early 1970s, in particular, here in the Valley, everybody thought of them in basically two ways, representing the two sides of the typical dispute. One was the risk and concern over outbound information. In other words, we're concerned that we keep control over our own information, that doesn't get out to the competitors. So that outbound risk was probably the major worry. But of course, on the other side, there would be companies that hired the people who left and caused the ruckus, and that inbound risk was also recognized, the fear of contamination. What we saw exemplified, for example, in the Waymo versus Uber case, with Mr. Lewandowski leaving Waymo and coming to Uber. And there were, we could spend a lot of time talking about what happened in that case. There's a number of lessons to be drawn. But those are the traditional ways in which we think about managing these kinds of assets. But there's another more, in essence, I think, long-term issue that strategic issue we need to pay attention to, and that is, like other assets, this, if it's properly managed, not only helps you keep things that you own, but it can elevate enterprise value. So part of the goal in understanding what the trade secrets are and putting in a good program for managing them within the enterprise means that you're going to be much better suited to bringing up the value of the enterprise with the information that represents these assets. So let's get started. We're going to talk about three things, why they matter, and I know this is a mixed audience, so for the lawyers here, I'm sorry, we're going to spend a minute or two on law. But actually, some of you are getting CLE, so that's important. So we'll talk about that and then get to the meat of it. Okay, you've seen this graph before, I'm sure, this being LES, because we care about intellectual property as a business asset. And when you look at the recent history of how companies have valued themselves relative to their asset base, we find this massive change that's happened in the last generation, reflecting the information revolution. Now, but while all that's happening, those very, very valuable assets that form so much of a part of the value of public companies are extremely vulnerable, mainly for the reasons that the PCT customers were telling me when I went around. It all feels so insecure. Hacking, and theft is just too easy with old thumb drives and that sort of thing. And then overlaid on that, we have this imperative represented here by Professor Chesbrough's book on open innovation. We have this imperative to share, because the old vertically integrated corporation just doesn't work anymore. And companies these days have to find ways to cooperate with various partners in their ecosystem in order to innovate fast enough to stay ahead. So really, how do you do this in this kind of environment? How do you maintain control? And that's the challenge. So like I said earlier, we're talking here about the oldest form of intellectual property, and it was protected for really hundreds of years, simply by threatening people with execution if they would make time with it. But we don't necessarily do that anymore, but there are incentives, and part of management is figuring out what kind of incentives actually work that will help you on behalf of your clients to keep control over the secrets. So here's part of the challenge that we face. And I'm sure this doesn't apply to everybody in the room, but it does apply to the lawyers. I know I am one. I understand this sort of thing, and I've hung out with other IP lawyers who, unlike me, are actually qualified to write and prosecute patents. I'm very familiar with this attitude, because back in the day, I mean, it was several years before I ever went into a federal courtroom. Trade secrets are a creature of state law, and all 50 different states, came to it their own way. And so it's never been very clear what's the doctrine behind it. So we think of it that way. And one of the reasons why there's a divide between these two is that, generally speaking, this was my observation, patent lawyers tended to view trade secrets as mysterious and something to be avoided. Not just because it was state court where you had to go to solve any disputes, but because we just didn't know what to do with them. They don't come in a nice, neat little bundle. There aren't claims written and all the rest of it. And so we were encouraged and sustained in this attitude by primarily, I think, the best mode doctrine, which allowed patent lawyers to say to their clients, very interesting information here related to the thing that you're going to get a patent. Of course, you are going to get a patent because that's the strongest form of intellectual property protection there is. And you have all this penumbral information that relates to it, and we're going to throw that into the application too, because we don't want to risk invalidity of the patent. Okay. We all thought that would last forever. But that's not how our clients see trade secrets. All right? Our clients see trade secrets as both assets to be monetized, protected and monetized, and liabilities. That's the risk part of their business. And so we need to, if we're going to be helping them, we need to understand this clear difference in perspective. Now, people are paying more attention. Years ago, trade secrets was not that interesting, I don't think. Apparently, it didn't feel that way to me. And recently, and I think there's a relationship between the growing interest in trade secrets and the growing size of reported jury verdicts. This at least grabs people's attention. It's not the most important thing here, but at least we know the cost, the potential cost of doing something stupid can be $2 billion. Right? And these are very typical because they involve people who get access to information in a way that they shouldn't, and then they use it in a way that may or may not help them. But if a jury gets angry, or a judge looks at what they have done and comes to the conclusion that it's morally unacceptable, they get punished with large verdicts. So we need to pay attention to these kinds of transactions so that we can get an appropriate attention from management to this issue, which again is bigger than avoiding jury verdicts. But this will help you, get management focused on the question ultimately. So now we pause to remind ourselves exactly what it is that we're talking about and what trade secret law means. First, context. We are talking about something that is almost infinitely broader in its scope of protection than any other form of intellectual property, because it protects information. If you were to imagine, and this is obviously an imperfect metaphor, but if you were to imagine the useful information of all sorts within a given business to fill a volume of space like this room, then perhaps, this will vary of course from one company to another, perhaps the amount, relatively speaking, of patentable subject matter among all that valuable information might be the size of a golf ball or even a basketball, but it's going to be a whole lot smaller than the information as a whole. And that's something to just hold in mind. So our basic definition of a trade secret is basically the same the world over, in large part thank you to TRIPS for doing that. Article 39 has this same structure. Information that is secret in the sense that it is not generally known or easily ascertainable, has competitive value from the fact that it is secret. It can't just be, I've got this machine hidden away and I paint it blue. It doesn't, you're keeping a secret, but you don't really derive any value from that. That's not going to help you. And then, and this is really core to the message today, it has to be protected by reasonable efforts. And in the case that Mark referred to, where I testified, and this was in Houston a couple of years ago, that was the issue. And this is interesting, we've lost the slides.
But you got infinity, Jim.
Yeah, we talked about the insecurity of the digital environment. So there was a case there that that I testified in, where the fellow who had left to join a competitor had sent ahead an unpublished patent application on a really core technology. And so the misrepresentation, in a sense, was pretty clear. It was going to be hard for anybody to deny it. And yet, because the company been really sloppy about its information controls, nobody had ever, stamped anything confidential, a whole bunch of issues. I was able to help the jury understand that they hadn't met that third requirement, and so they rejected the claim overall. How many stories do you think you can collect over 50 years of people doing stupid things? Yeah, no, but look.
Greatest hits.
Yeah, greatest hits. Okay, well, let's, I said there were a lot of lessons to be drawn from Waymo versus Uber. Let's talk about that one for a second. And then on the transactional side, let's talk about fairness. Or what I sometimes refer to as the dark side of trade secrets. But what happened with Waymo started with, the driven vision of, what was his name, Kalanick, who ran Uber? Kalanick. And he was absolutely convinced that the future of the company was solely in self-driving vehicles. So and there was one guy who he was convinced, really, really understood it. And so he focused his efforts on trying to convince Lewandowski to come and join Uber. And Lewandowski, for a whole bunch of reasons, decided that was a good idea. And he never really explained exactly why he did this. This is typical of the stupid decisions, by the way. He downloaded thousands of confidential files, put them on some disks, and he at least told the people at Uber that he had done this. And so Uber, because it was focused on trying to get him to come there, said, well, look, we can really kind of make sure that none of that information finds its way here. And he said, yeah, that won't happen. I've already taken it to the dump and destroyed it. Later, by the way, they found the person who was in charge of the dump and talked about how he came there and tossed them the discs. Anyway, so they said, in order to make this happen, we will basically agree to fund the new company that you're going to start a few months later. But you got to leave and start something now, but we'll have our side agreement. They didn't want to wake up Google/Waymo, I think, to what was going on. And here's where it gets really interesting. The agreement that they signed with him included a hold harmless, an indemnity against any claim that Waymo might make over the misappropriation that they knew about. They knew that this had happened, and they said, we will indemnify you against that claim. And of course, as this all rolled out and all became known, which happened, by the way, because somebody made a smaller stupid mistake, which was send an email to the wrong address. It was intended to go to Uber, and it went instead to the relevant people at Waymo, and whoops. Yeah. And so, are you able to? Okay. What happened as a result of that was, in trying to prove the case against Uber, Waymo had a huge advantage because they said, "Look, we have to demonstrate that you knew or should have known that this was improper conduct, and you were just tied at the hip with this guy because you had agreed to indemnify him." And they worked really, really hard, and apparently were successful in convincing the court, at least preliminarily, that none of that specific information that he had taken, none of those files had migrated over to Waymo. But as the judge pointed out, there was always the question: if you have Anthony Lewandowski coming over and sitting with the engineering team at Uber, how do we know that he's not directing the engineering decisions as a result of information that he carries in his head from all of that work that he did over at Waymo? And so you heard the story. This was, by the way, probably a hotter ticket in San Francisco, the trial, that case, than APEC is today. And yet the trial settled after 4 days, $250 million or something like that. Big numbers. So this represents an instance of blow up over what I call the recruiter's dilemma. And that is, when you go out to find a really highly talented person in an industry that's small but growing, there's not that many people who are really good at it, then you want to be able to say, I'm just hiring somebody for their general skill and experience, not for any trade secrets, right? That's another one of those perhaps vague dividing lines. But we tell people we want to hire you only for your general skill and experience. And yet, the perfect hire for one of these really special positions is somebody who has solved that problem for the competitor and already knows how to get there in the most efficient way possible. And that's the roots of the dilemma, and that's what got Uber in trouble. Oh, this is encouraging. See, it takes a trade secret lawyer. All right. Where are we? Okay, I'm back a couple of slides. Let's see. Let me try to see. Yeah. Okay, here we are. So, like I was saying, segue, skill and general knowledge, not covered. And here's the thing, trade secrets, while they are potentially permanent, there is, by the way, a set of trade secrets that have existed for over 400 years. The Armenian family that makes orchestral cymbals has kept it all within the family. Can you imagine what their Thanksgiving dinners are? They've kept it all for over 4 centuries. So it is potentially permanent, but it's not exclusive. You can't keep somebody else away from it by, as you can with a patent. They are always able to independently discover the information. And as a result, you can have 2 or more companies within the same industry having the same trade secret, each of which protects it and controls it for themselves. And it may have theoretically less value because of that, but until a large number of the companies in the industry have the same secret, it doesn't become generally known. So those are the basics, all right? So,
Could you talk about reasonable efforts for a minute?
yes, actually, what we're getting into, thank you for that, Suzanne. When we talk in a moment about management of trade secrets, this is directed at both the day-to-day business management, but also with an eye towards being able to prove, if you ever have to, that you have exercised reasonable efforts. They are basically one and the same. When I go to testify as an expert witness about what a company did or did not do that relates to reasonable efforts, what I'm doing is basically reverse engineering the same kind of advice I would have given them if I had gone to talk to them about how they can improve their management programs for handling this kind of information. So it's all of one. The reason we talk about reasonable efforts is because that's a legal standard that will apply in courts, and that should matter to us. It's not the be-all and end-all. So again, to emphasize the point made earlier about trade secrets being broad, here we have examples, and you can just imagine what in your own company or in your client's companies might be similar categories of valuable information. This is the kind of thing that we're talking about. It's not just technology. It's anything that helps the business achieve or maintain an advantage over its competition. Okay, finally, now here we're getting into the management part of this, which is really about reasonable efforts. So, what is it we're trying to do here? The objectives. Like I said before, we want to prevent loss. That's the outbound risk. We want to avoid contamination. That's the inbound risk. We want to be able, this is something to think about for boards of directors, we want to be able to comply with emerging standards around this, which includes the general obligation to husband and care for the company's assets and to use those assets to increase value of the enterprise. And there are more and more agencies that are starting to tip their toe into this. The FTC has taken certain actions where directors have not looked hard enough at information security issues, and I suspect the SEC is going to broaden its interest in these sorts of things too. And there are general standards that have been issued through the IT community, like ISO 29000 and the NIST cybersecurity framework. So we're getting this sense that there's a body of standards that we need to pay attention to. And then, of course, at the bottom of the list here, but very, very important, is that if, God forbid, you ever have to go to court, you will be able to demonstrate reasonable steps. That's the reasonable steps is the TRIPS standard. Reasonable measures is the Defend Trade Secrets Act federal standard. Reasonable efforts is the Uniform Trade Secrets Act state law standard. Got all that? Doesn't matter. It's all the same. All right. So, looking generally at this, what's the mechanism? What's the framework for understanding whether we're trying to help a company that really doesn't have any kind of program at all, or whether we're looking at an existing program to try to help improve it? What is the methodology? So really, this boils down to nothing more than a variation on classical risk management. So we look at the asset that we're trying to protect, the value of the information. We have to know what it is, right? And we look hard at that. And we understand our trade secrets, at least in categorical terms. There's a lot of controversy over whether and to what extent you should list, reduce everything to an atomized list. And generally speaking, I think the answer to that is no, but you do need to, at least at a categorical level, so you understand this. So you bring management into a room and you ask them, what is it that causes you to lose sleep at night about what the competition might find out? And that conversation will lead you to an understanding of what are the most valuable secrets. Then you take a look at what is the risk that something bad might happen to them. What are the threat vectors? And as we'll see, the number one most important and most consequential threat vector is the workforce, our employees. It's the insider threat. We have very, very good tools that protect against cyber theft and so forth, or at least reduce the risk pretty substantially. And but as managers of the process, we really need to think quite a bit about people. We'll get into that in just a second. So what's the likelihood that the risk will come to pass? And so you have this analysis. And that then becomes the context for you to consider what can we do to reduce, mitigate, sometimes eliminate, or transfer these risks as far as the company is concerned. And we need to keep in mind, when you're talking about information security, every single thing you do comes at a cost. Either because you've got to hire somebody to implement it, because you've got to buy some package, or more frequently, because you institute a procedure that people find annoying. Okay, think two-factor authentication when you first had to start dealing with that. Right, so all security has that kind of cost. And what we need to do as managers is to figure out what can we sell to the workforce? How important is it? How much pain can we inflict on people in order to produce that benefit, and hope that they'll understand that and not try to work around it. Okay, so that's the basic process. And as I said, I'm going to talk about 3 areas of risk, and then we'll basically be done. People risk. We've already talked, we had a wonderful opportunity to talk about the Waymo versus Uber case to illustrate the recruiter's dilemma. We have to recognize this is an issue, particularly in fast-growing industries and companies. When we deal with people who are coming into the company, we need to certainly understand what it is, what kind of constraints they are under, what they've been exposed to. We need to do a mini risk management process around that person coming in. I mean, I have clients, and I'm sure many of you do too, who will call you when they're hiring somebody, when they're bringing somebody in who's very important to them, but represents a risk because they're coming from a competitor. And you engage in what we refer to sometimes as a scrub, making sure that when they do walk in the door, they don't have anything, they've been told not to reveal anything or use anything, and the people that they're working with have been told to cooperate with them in that. So we end up being very careful about recruiting and onboarding. That's the first phase of the employment relationship. Then there's a big middle phase where everybody is doing their jobs. And while we're there, the most important thing that we can do as an enterprise is focus on training. Because, again, we're getting back to the original theme. People do stupid things. Not venal things, stupid things. And that's because they don't understand. So, it's an easy syllogism. If we can help them understand, if we can make them smarter about what the risks are and what their role is in the enterprise to protect these very valuable assets, they are much less likely to make mistakes. So, and training, good training, and I'm not talking here about, 3 or 4 minutes on an hour-long code of conduct thing that's on the web, but actual training, where you talk to people about the environment that we have in this company and what your expectations are of their behavior. And then, of course, the final phase is termination. And here, it's really shocking what you see happen in some companies, even companies that have been around for a long time and have systems. How many of them don't turn off somebody's credentials to get into the company systems when they leave? But that's not the biggest problem. I want to focus here and draw your attention to the exit interview. And classically, the exit interview has been designed and often implemented by HR. And their primary interest and goal is to find out why these people were unhappy and leaving, right? That's kind of it. What could we have done to, keep you here and so forth? As opposed to, oh, where are you going? You're going to a competitor? Ah, okay. What are you going to be doing there? Have you given any thought to how you can perform those roles while still maintaining in confidence and protecting the integrity of the information that we've shared with you here? That conversation is really important, and it often leads to another communication with the IT department to do some forensics that will help you understand the risk environment that you're in. Because what often happens is we don't pay any attention to it. We let people go, and we don't look at the risks as we're able to. Oh, that's risk area number 1. Number 2, processes. In order to make all of this work, you need to organize the way that you're doing it and to help communicate to everyone the reasons why you're doing it. You create good, understandable, not overwhelming policies, ones that people can actually comply with, and that you can monitor to make sure that they comply with. 2 important points here related to what we've already talked about. Access controls. We have this thing, the principle of least privilege. You let people get access only to the things that they need to know in order to do their jobs. And modern information systems allow us to do that very, very effectively. Now, what happened, for example, in the case I testified at in Houston a couple of years ago, they had a huge group, the company, the plaintiff, had a huge group of engineers, all working on different projects. They could have partitioned the database, the relevant engineering database, to allow people only to see the things that they were working on. Instead, they decided that they wanted everybody to have access to everything so that it would enhance collaboration. That's not a stupid thing to do. That makes sense. It makes particular sense if your business model and what you're producing is something that is affected mainly by patent rights, which was the case with this company. It was making undersea drilling equipment, and competitors could examine it pretty carefully. So you wanted to use patenting. So everything they did was around patenting, and they tended to ignore secrets. So, but if you are focused on maintaining control over your stuff, then access controls are critical. And that goes particularly to endpoints. I don't have my cell phone here, but of course that's another thing back in the early 70s that did not exist, right? We didn't give every employee a handheld, very powerful computer that they could use to get access to all the company's systems. Oh, and by the way, these are all people who have been trained carefully over the last few years by social media that it's a really, really good thing to share. right? So they go home at night and they use that same little device to engage with social media. And so we desperately need endpoint controls, that is, controls over the places where the information ends up so that we can watch what happens to it after that. Okay, and the final risk area is management of our processes. And I picked 3 parts of that to emphasize here. I think in all the business-to-business cases I've seen, the most common source of problem is bad NDA management, which starts with what goes into it, because people tend to look at the NDA as just a form. You're going to sign yours, you're going to sign mine, I don't care. As opposed to a contract. And there are some variations that can be really important there. And, nobody pays much attention after whatever the relationship is, has sort of run its course. We're really excited about the beginning. It's kind of like a romantic relationship. And we're infatuated and it's great. And then, we're together and nobody thinks about, the ultimate necessary divorce. And we forget what we learned in kindergarten about cleaning up and, putting things away. And so a lot of stuff sort of hangs around and becomes fodder for trade secret cases later on. So the international supply chain. So let me just say a word here. The enforceability of trade secret rights as between the US and almost every other country in the world is very different. In large part because we have discovery here, which allows a trade secret owner to find out what happened. And in most civil law jurisdictions, you can't do that. But it goes well beyond that, and we can spend a whole day talking about the variations. But as a management issue, you need to think about what you can do in a contract and relationship management perspective to increase the level of control that you have over information that you must share with somebody who's thousands and thousands of miles away, living under a different cultural and legal system. And then finally, litigation avoidance needs to be top of mind for us because I don't know how many of you here might have been inside a company that got involved in a big trade secret case, but going to trade secret university is not really worth it. And no matter the outcome, the cost to you in terms of diverted attention and risk and so forth is crazy. So we need to pay attention to that. Now, my final point. What do you need to do? This is the without breaking a sweat part here. This is not hard. If you can somehow get management's attention that the issue is important, that in our company we're taking a whole lot of risks, and boy, they could come back to haunt us, then the good news that you have for them is it's not hard to reduce those risks. And you can come up with a program that works for your company in its environment, its risk environment, in its industry, fairly easily. And so stop using words like audit and inventory. It creates the impression that in order to understand what your trade secrets are, you have to, like the neighborhood hardware store, shut down for a weekend and count all the nuts and bolts. That is not what it takes to understand at a level to put together a reasonable plan. Now, critical, and I have this point here, manage to the risk, not to the rules. Keep everyone's focus on what the risks are. You don't just sort of download some policy or set of rules from some other place and figure that it's going to work for you. That will be an expensive mistake. Central authority with distributed responsibility refers to the fact, yes, this is shared, among all the people who are involved with the different functions and business units in the company, but somebody has to be the champion. Otherwise, this thing won't really work. I spent, about 6 months ago, I spent a better part of a week in Taiwan with this fellow named Fortune Chick, who runs the trade secret program at TSMC, which many of you I'm sure have heard of, which probably has more customers with very, very high-end confidential information than just about anybody in the world. And over the space of about 10 years developing this, he has put together, he's been the champion of their trade secret program, which over that period has produced 40,000 disclosures. They have eclipsed the patent department in terms of getting people to share innovations with management. And it's because he has all the energy that it takes to make something like that happen. Now, you don't want to necessarily try to emulate TSMC, but the notion is having somebody who really cares about this stuff matters. And what they will do, among other things, is ensure that we take a look at whatever it is that we're doing on some sort of regular basis to make sure it's still fit for purpose. There we are. Thank you. I don't know how that messed with our time or question. Okay, we are good. We're not going to move to questions. Mark is going to help you with questions.
Mark?
Sue.
Thanks, Jim. Very insightful. Going back to one of your first or second slide on the definition, I noticed the word independent was not in the definition. Can you elaborate on the use of the word independent economic value and its significance?
Very good. And it's, have you been reading the case law recently? There have been a couple of cases just in the last year that have keyed off of an academic article written actually by one of my former students from Berkeley, Camilla Hardy, and together with Mark Lemon here at Stanford. And one of the things that they pointed out was that judges in deciding these cases have looked at the phrase independent economic value from secrecy, and they've just considered, well, is the product or service valuable? Does it add to the business? And so they criticized it in this article, and these two decisions I'm talking about picked up on that. And they said, wait a minute, this one case in particular where the plaintiff, who believed it to be a victim of trade secret theft, tried to prove value in relation to the product that it was selling. This is our most important product. It was a software product. And it generates all these revenues. Therefore, it's valuable. In fact, we've been offered X billion dollars for the company. And this product forms the massive part of our value. And the judge says, no. That's not what this is about. It's not about the intrinsic value to the company of the thing. It's about the incremental value that you get from treating it as a secret. So you have to think about it in that way, and you have to organize and present your evidence in that way. So a really good question. Yeah, we're paying much more attention now. Judges, I can tell you, 30, 40 years ago, they didn't pay attention to reasonable measures, reasonable steps. They just said, oh, okay, you have a guard at the front door, people have to sign in, okay, check. That's good. And actually there are still some judges who kind of they accept the checklist approach to reasonable measures that starts with the fact that everybody has passwords and there's IT hygiene within the company. But a growing number of judges will never accept that kind of simplistic approach. Yes?
I do have a question. This was regarding the policies and access control slide. Do trade secrets need the policies and the controls? Do they need to deal with trade secrets separately from other confidential information?
Oh, another wonderful. Oh, thank you. I didn't plant these people, but you guys are asking very, very insightful questions. One of one of the things that drives me crazy, and I don't want to make this too long, but there's a historical grounding in this that comes from 1939 in the publication of the first restatement of torts, which defined for the first time and kind of a national level what trade secret law is all about. And it took a very cramped view of what you could claim as a trade secret. You had to be in continuous use in the business and so forth. Ephemeral information like bids weren't covered. Failed experiments, which forms the vast body of very, very valuable R&D, not covered. So the courts had to develop this other category and figure out a way to protect it. And that's how we ended up with parallel systems for sort of trade secrets and confidential information that did not, quote, rise to the level of the trade secret. So that phrase is really grating for me to hear, because under modern trade secret law, the level of, quote, novelty, and I hesitate to use that word because it's not novelty in the patent sense, but the minimal requirements that you have for something to be actually useful, right, is very, very low. So qualifying information is really not a problem anymore. And so we should stop using the term confidential information as compared to trade secret. In fact, the most useful use of that terminology is with the workforce, because the workforce doesn't understand what a trade secret is, but they know confidential. We've known that since grade school, right? When all of our secrets were exposed on the playground. And so we use these terms, proprietary, confidential, and so on and so forth, not to make any artificial distinctions, but to help people understand what we want their behavior to be. But it's really hard to kick these old habits, and so we see a lot of reference to confidential information. I have a piece on my website that deals specifically with that. Yes?
Hi. I'm wondering how far we should be going. We manage a startup, and I'm wondering how far we should be going with NDAs. So, for example, we make widgets. When we have a partner who might want to buy our widget, we definitely put an NDA together when we send anything to somebody else. But we also order tooling from various folks.
Right.
And so these are just vendors who make a product. They have their designs, and then they send us our product. They couldn't make what we're making because they don't have everything else, but they know something that we wouldn't tell anyone else.
That's right.
So where do you draw the line with NDA and practicality and all that?
When you're having a unique and custom part built by a vendor, they should sign an NDA because that information is confidential to you. And you don't want somebody to be able to get access to that and figure it out. You don't want them to be making that same part for somebody else. So it's quite fair for you to say, look, we're sending all these specs. Those specs and the other, we have design information and so forth, those have to be covered under an NDA. Normally they will sign it because they want your business. The harder part sometimes is checking to make sure if they've complied. All right. Yes, we had a question in the back. No? All right, sure.
So we're the Licensing Executive Society. We're talking all about best practices for licensing trade secrets.
Yeah. First of all, you got to do what we talked about here, right? Which is know what you have and engage in an effort to, if you will, protect them and put them in a safe place in your working environment. And then you have something that can be more rationally characterized as an asset. But of course, once you've done that, that just helps you know what you have. And if you're engaged in licensing that, then you enter into the difficult world of doing the dance around how much exposure you're going to allow to your secret and how much the recipient and potential partner is going to want to expose themselves to. And that's a very, obviously a very challenging kind of thing. Usually we use, incremental exposure to get people to the point where they sign a harder and harder NDA that gives better and better protection. And then of course there are all sorts of valuation issues that you run into, but all I can say is it's hard to get anywhere if you haven't done first what we've talked about here. So you know what you have and you've put it under a protective regime. By the way, on licensing, there's another article on my website. I send these things out almost once a month. I've been doing it, got over 60 or 70 of them now. There's one that talks about when the secret informs the brand, and it's about the relationship between secrecy and trademark and branding, and it's the story of the Listerine trade secret, which I used to teach in law school just about the trade secret part because it was really interesting. The contract, by the way, 2 sentences long, the license agreement from the 1880s for Listerine. They gave G.D. Searle, was the fellow who bought it, right, who licensed it. And like I say, the agreement was just 2 sentences long, had a certain dollar amount per case of Listerine that was going to be paid, no other provisions at all. And in the 1930s, because Listerine had become finally popular, somebody figured out the formula, and so ultimately the company that had gotten the license went to court. In a 1957 decision, the court in New York said, no, you've got to keep paying this royalty because you made the contract. You have the choice to stop making Listerine if you want. It doesn't matter that the trade secret is not there anymore, right? And so that's a lesson about the power of contract. But the more interesting story is what happened, in between. How did it become popular? And it was because the son of the guy of G.D. Searle, who took over management of the company in the 1920s, decided that this thing really, they were just trying to sell it to dentists and it wasn't getting anywhere. He said, we've got to sell this to the general public. And it's the first example of fear-based advertising. Making people feel that something was wrong with them, that they needed this product for. And it inspired him to come up with the name of a brand new disease that didn't exist. Halitosis came from his desk. And a lot of interesting taglines from the advertisements over the year. We use always a bridesmaid, never a bride. Your best friend won't tell you, right? Those things came from Listerine. Anyway, I like the quirky historical stuff. Yeah.
Jim, thanks for the talk. What advice can you give to small companies and startups that don't have either the management resources or the budget to implement the ideas you put forth on your slides?
Yeah, well, another wonderful question, and it's something that that hits right at my heart because I've grown up professionally here in the Valley, and I understand that the focus of most startups is to get product out the door, get the next round of financing, and so on and so forth, and so this can seem a very distant and theoretical risk, and so the answer to the question is, at some much lower level of focus and time, you can take care, it's like the 80-20 rule, you can take care of most of the risk with a very modest amount of effort. All you need to do is sort of get people who, and there's not that many people in a startup, right? You get people in the room, what is it that we really care about? How are we going to be careful about this? And can we have some rules around the NDAs and who we're going to be talking about. So, we can come back and let's meet about this once a month and see where we are. That's great. I mean, that's better than nothing. And then you carry on from there. I have, in my book, I have a suggestion for people who want to start, very, very small and limited, and then you add things as you go on. Yes, Suzanne?
I say when you deal with litigation cases, it oftentimes comes down to some common sense things that you can do, right? So how do you mark your presentations? Do you mark things when they're confidential, when they have a trade secret? So consistent marking becomes important.
Sure.
When you have employees leave the company and you're telling them, hey, you have a trade secret, they say, great, tell me what it is. Like, not just, hey, you don't have trade secrets, you have to tell them kind of more specifically what they can't talk about, right? Can't talk about these kinds of things.
Well, on the way out, it's generally acceptable. Look, all of this is about communications.
Correct.
All communications, right? So we mark things so that people who see the document or whatever it is have received a communication about what our expectations are of what their behavior is going to be. And same thing when somebody is leaving. We remind them,
Correct.
But we don't need to tell them
Well, but if they didn't know if they had access to trade secrets, you need to let them know.
Oh, yes.
So they have to know that they had the secret.
Exactly. No, you're reminding them that they have, but you don't need to get into the granular details of it. At categorical level is okay. And again, if you engage in that kind of conversation, this is just to remind you, you've been working on this rocket fuel over here and this sort of thing. And that's very, very sensitive stuff. Do you have any concerns? And that's the time when they have to say, well, no, I don't know what you're talking about. I never worked on that project, right? And so then you at least have some information that you need to process in order to actually understand what the risks are.
So investors, I work a lot with startups, and as you know, investors don't sign NDAs, generally speaking. So
Yes.
a venture capitalist, especially in the early stage, is not going to sign. They are trying to minimize their risk because they see a lot of similar technologies. And
Right.
other service providers have actually adopted that approach. And I would tell a client coming to me, keep it to a non-confidential level. And I don't think all of them know how to do that. So what would be your advice if you really, really need funding? You have to shop it around to many, many people. The secrets are out, and how would you recommend that a startup approaches that?
Yeah, this is probably the most essential conundrum that startups face, because they have to develop a business, they have to get their company funded, and yet they're dealing with people who don't, on their own side, and for understandable reasons, want to take on the burden of secrecy, particularly if, like venture capitalists, they're involved in many other things. And so it takes some really hard thinking about what kind of incremental disclosure process can you go through that maintains the maximum amount of control while you give a little bit more and then a little bit more, to the point where they finally trust that you do have the greatest things in sliced bread, and they're willing to enter into some sort of relationship that gives you some level of assurance. Alternatively, you tell them, look, there has to be a way for you to understand that what we're talking about is real without our spilling something that would eliminate the value of our asset. And so we've got to go figure out who we can trust perhaps on the side to do experimentation and demonstration and so forth. This is where, by the way, we get into the Theranos effect problem. I call it the Theranos effect now, because the level of concern and skepticism that you get from people can be greater, because of what we saw happen with Theranos, where they basically faked their demos and told everybody, no, you can't see anything because it's all a secret. And that's why, by the way, there weren't any leading venture capitalists in that investment. But it's purely practical, and you have to get to the point where the relationship, you've developed enough trust in the relationship that you're willing to take some risk and they're willing to take some risk. I mean, obviously, venture capitalists, when they receive all this information, they don't sign non-disclosure agreements, but they do appreciate that if that information gets out and they hand it over to somebody else, there's going to be a big problem, and you know, they have a continuing business to handle themselves.
Jim, so I'll mention one thing. I don't know if you go by James or Jim, both. Somebody with all agencies said early on, because we have a security team, he's not constantly, but he would often remind me, every layer of security will cost something.
Yeah.
And it was his main point to every of his clients after he left he never, anyway, the point is, even those in the business realize there's a cost to every level of security one puts in.
There is. A related saying that you hear sometimes is, you know, the harder you squeeze your fist, the more leaks out through your fingers. And sometimes the people who try to institute a really crazy, heavy burdened security system will find that no one pays attention to it, and that the information just gets out because no one can live with that. All right. Well,
I have a question, Jim.
okay, Joe.
I have one, possibly two questions about trade secrets and license. So, in a development scenario, parties are always fighting over who owns the newly generated IP rights. And, that makes sense for patents and copyrights. Does it really make sense for trade secrets? I mean, does ownership of a trade secret really mean anything more than possession? Does it give you a special right of enforcement or usage or something like that?
Well,
or other rights?
Okay, there's two different parts to that. One is you have to be at least an authorized possessor in order to have standing to bring a claim for somebody misusing or disclosing that information. You can share that with others. But when it comes to the people who both have access to it and who have shared it, then ownership can be really critical, because if you're in a confidential relationship with somebody and it's one where the information was developed jointly, then you need to solve that problem and make sure if you're going in your separate ways that one person's going to be the owner subject to specific rights to the other. Because if you have two people independently with total control over the information, all of a sudden your ability to demonstrate reasonable efforts has dropped dramatically, because that person has the right. This is one of the reasons why we have employees who are writing code, put in the magic language about work for hire, right? So that we can retain control over it, and without that, you can't have a trade secret because you can publish wherever you can put it on GitHub.
Is it a matter of specifying who owns it, or is it more a matter of sort of mutual confidentiality, so that neither party destroys the other party's trade secrets?
You can handle it that way. I mean, the risk is that the other party is going to do something you don't want them to do. So if you can take care of that in your agreement, fine. You don't have to stick an owner label on one to the exclusion of the other.
Thank you.
Okay.
Thank you very much, Jim.